Are you a US citizen and you want a family member to get a green card and you don't know where to start? Well, you're in the right place. The green card is the US permanent residence. It allows you to live and work in the US, and it can change your life and your family's life forever. What I'll explain in this video is critical, because on this depends if a child can get reunited with his parents, a couple can get married, etc. US citizens can get green cards for some family members. I'm Julio, immigration lawyer, and you can petition your parents, your spouse, your children, your siblings, and even your fiancé with the K-1 visa. Under certain circumstances, you can also petition for your step-parents, your half-siblings, and your step-children. Each of these family categories has different waiting times, and it is essential to know this, because in some cases the delays can be quite long. Typically, you will need more than one immigration form to petition a green card. But there's one that is fundamental, the I-130. In this form, you must prove that you are a US citizen. And you can do it, for example, with a birth certificate, a passport, or a naturalization certificate. And it also serves to demonstrate the relationship between the US citizen and the family member to whom we want to petition a green card. For example, a birth certificate that proves that the citizen is the father of the child, or the marriage certificate for the process between spouses. Oh, and don't forget to subscribe so you don't miss any news or video and you can be part of the largest immigration community in the world. First of all, a US citizen can petition for his or her parents. For that, the US citizen must meet certain requirements. Must be 21 years old and must be domiciled in the USA, or intending to be domiciled in the US by the time the petition is approved. In other words, if the citizen child lives abroad and is not planning to move to the US, he or she cannot petition for his or her parents. Also, every US petitioner in any family category is the sponsor of that family member. Must be able to qualify as a sponsor, and if not, should get a co-sponsor. You can get a green card for your parents if they are inside or outside the US. If they are inside, be very careful. You have to see how they entered the US. If they enter with permission, meaning they enter with a visa or parole, you can get them a green card even if they overstayed or they work without authorization. But if they enter without permission, it can get complicated. There are a lot of people here in the US in this situation and they cannot fix it. However, there are some legal exceptions. For example, the 245I, the military parole in place, VAWA, U visa, and the I-601A waiver. You can also petition for your parents if they are outside the US. In that case, you will have to go through the consulate where they are residing. Waiting times vary a lot and they change all the time. However, this is one of the fastest cases because parents are immediate relatives, and there are unlimited green cards available to them. But you know, government bureaucracy still delays cases. In general, petitioning for your parents is faster inside the US between 6 to 12 months, and slower outside up to over a year. But again, this can change at any time, for better or for worse. An adopted US child can also petition for his or her parents, if he or she was adopted before the age of 16. You can also petition for your step-parent. For example, if your stepfather married your biological mother before you were 18 years old. The same would be true if your stepmother marries your biological father. A US citizen can also petition for his or her spouse. Note that same-sex marriages are also valid. To petition for your spouse, you must demonstrate that the marriage is true, is bona fide, and not for the sole intention of getting a green card. Keep in mind that marrying a friend or a neighbor not for love but for the green card is a federal crime. Also, forget about fixing your papers in the future. Of course, every time I say this, there are people that say, oh, but my cousin Johnny married for the papers and he got them. But this is illegal and can get you in serious trouble. Since the government knows that many people do fraud, they will pay close attention to these cases to see if this is a real marriage. I always recommend people to submit a lot of evidence. Evidence can be photos of the wedding, of the families, joint taxes, joint bank accounts, utility payments such as gas, water, electricity, or internet in both of your names. Obviously, if you have children, this is considered to be the strongest evidence. An important issue is that all documentation must be in English. If it is in another language, it must be translated into English. The government usually does an interview in the US with your spouse to determine if the marriage is real or not. But we've seen lately with some clients that they did not have an interview. and the case was approved. This usually happens when the clients have strong evidence. If you go to the interview, they can ask you whatever they want. We've seen cases that they ask what is the color of your husband's toothbrush, what side of the bed your wife sleeps on, make a drawing of your bathroom, etc. And if the officer has doubts, they can conduct the interview separately to see if you're telling the truth or not. Obviously, this is always a stressful situation, but for that reason, we must go very well prepared, with all the documentation at hand and very well organized. Remember that if you were married less than 2 years at the time you get the green card, you will only get a conditional green card valid for 2 years. You should then ask the government to remove the conditions and give you a permanent green card. They do this also to confirm that the marriage is for real. We are talking about recent marriages, so the suspicion is higher. A US citizen can also petition for his or her children. Keep in mind that if the children turn 21, the cases will take much longer. At the time of making this video, it's taking around 8 years. And if the child is Mexican, 22 years. But if the children gets married, this is even slower, it's taking around 13 years. And if the married son or daughter is Mexican, it's taking 26 years. These delays can get better or worse every month. And you can check this in the visa bulletin published by the government. If the children are under 21 and unmarried, the cases will go much faster. This is again because there are immediate relatives and there are unlimited green cards for them. In general, petitioning for an unmarried child under 21 is faster inside the US, between 6 to 12 months. And if the child is outside the US, it may take longer depending on the consulate. You can also petition for a stepson if the citizen stepfather marries the biological mother before the child turns 18. The same applies if the citizen stepmother marries the biological father. A US citizen may also petition for an adopted child if the parent adopted the child before the age of 16. A US citizen can also petition for his or her boyfriend or girlfriend or fiancé. You can do it with a K-1 visa that allows the fiancé to travel to the US with the intention of getting married. You must have physically seen each other within the last 2 years of filing the case. Once your fiancé obtains the K-1 visa, they can travel to the US. And once inside, they have 90 days to get married with the US citizen. And then the US citizen starts the green card petition inside the US for his or her new spouse. At this time, the K-1 is a little backlogged and is taking more than a year. But this may change anytime. And then you must add several months or even a year inside the US to get the green card. A US citizen can also petition for his or her siblings. Unfortunately, this is one of the slowest cases and is taking currently around 16 years. And if your sibling is from Mexico, India, or the Philippines, even longer. You can also petition for your step-sibling and your half-sibling. You can petition for a step-sibling if the step-sibling relationship was established before one of you turned 18 when the parents married. This, with a simple example, is I'm 25 years old and my stepbrother is 17. Since one of us is under 18, it can be done. And it doesn't matter which one of us is a US citizen. And you can also petition for a half-sibling. You have to prove that you share one of your parents. You can also petition for a green card for your adopted sibling, if the adoption occurs before your sibling turns 16 years old. As you can see, some of these petitions may take a long time, and some are faster, but they can change at any time. Or eventually the US Congress may add more green cards, which would speed up the process. You can start your family green card by clicking on the link in the description of this video.